Community Services.
Thank you, Madam Deputy Speaker. As I present a bill for an Act to amend the Police Powers and Responsibility Act 2000 and the Corrective Services Act 2006 for particular purposes and to make consequential amendments of the Act mentioned in the schedule. So I now table the bill and explanatory notes, and I also nominate the Legal Affairs and Community Safety Committee to also consider the bill. Madam Deputy Speaker, I am pleased to introduce the Police Powers and Responsibilities, Motor Vehicle Impoundment and Other Legislation Amendment Bill 2012. The bill fulfils the government's commitment to introduce the toughest anti-hooning laws in the nation. This bill amends Chapter 4 of the Police Powers and Responsibility Act 2000. This chapter provides two schemes for the impoundment and forfeiture of motor vehicles, namely Type 1 and Type 2 motor vehicle impoundment schemes. The Type 1 vehicle impoundment scheme applies to a range of traffic offences commonly associated with hooning. The Type 2 vehicle impoundment scheme applies to offences such as unlicensed and unregistered driving. And this government has recognised that the community concerns about hoon drivers and has acted to address this menace. This bill increases the impoundment sanctions for Type 1 offences to 90 days impoundment for a vehicle used to commit the first offence and forfeiture of a vehicle if another Type 1 offence is committed within 5 years. The bill includes evade police and high-end speeding as Type 1 and Type 2 vehicle-related offences respectively. The nature of these offences warrant inclusion into the vehicle impoundment schemes and highlights the government's commitment to stop inappropriate driving behaviour. The bill also increases impoundment sanctions for the Type 2 vehicle impoundment scheme. The new impoundment and forfeiture sections will be a 7-day impoundment period with a Type 2 vehicle-related offence is detected, an automatic 90-day impoundment upon the detection of a third Type 2 vehicle-related offence within 5 years, and automatic forfeiture of the vehicle used to commit a fourth or subsequent Type 2 vehicle-related offence within 5 years. The bill will also improve the operational and administrative efficiencies of the Type 1 and Type 2 vehicle impoundment schemes. Both impoundment and forfeiture processes will operate administratively rather than through a court application. Currently, for a vehicle to be impounded for 3 months or forfeited to the state, an application must be made to a court for an order that a vehicle be impounded or forfeited. By allowing vehicles to be impounded or forfeited automatically, considerable savings for both the police and the courts are made through reducing the time taken by police officers in preparing court applications and reducing court time required to consider applications. There are a range of other amendments in this bill that provide for more efficient savings. For instance, traffic infringement notices will be allowed to be issued to offending drivers rather than restricting the vehicle impoundment scheme to proceedings that are normally started by notice to appear or arrest. This allows the defendant to elect to pay the fine rather than appearing in court and results in productivity savings for both the QPS and the courts. This bill also gives police officers more flexibility in the way that they can deal with vehicles used to commit impound offences. Currently, impounded motor vehicles can only be towed and stored at a holding yard. This doesn't work for regional areas that have no tow trucks or holding facilities to store impounded vehicles. This vehicle provides police with a number of alternative impound options, including clamping, removal of number plates, and the issue of motor vehicle production notices. These options allow impoundment sanctions to be applied regardless of the differing circumstances that may exist across Queensland. Another improvement made by this bill focuses on the release of motor vehicles that have been impounded by police. To mitigate concerns that some of the members of the community may have about the impact of automatic impoundment and forfeiture, the bill provides a mechanism whereby the usual driver or owner of an impounded or immobilised vehicle may apply to the Commissioner for its release depending on certain circumstances. The Commissioner has 5 business days to decide if a vehicle should be returned to the applicant, allowing vehicles to be returned to persons in appropriate circumstances and within reasonable timeframes. An aggrieved applicant may appeal the Commissioner's decision not to return an impounded vehicle. Finally, the bill amends the Corrective Services Act 2006 by providing that remanded prisoners may only be classified as maximum or high security. This reduces red tape and aligns with the Department of Community Safety's commitment to redirect resources to frontline services. Madam Speaker, Deputy Speaker, this bill sends the strongest possible message to those Hoons who think that they can use our roads as a racetrack. If you're a Hoon, police will impound your vehicle, police will clamp your car, and if you still don't get the message that hooning on our streets is unacceptable, police will crush your car. The community has enough, and this government will protect Queenslanders by taking hooning vehicles off our roads. I commend the bill to the House, and I move that the bill be read a first time.
The question is that the bill be now read a first time. Those of that opinion say aye. Those against no. I think the ayes have it. I call the clerk.
Police powers and responsibilities.